If an appellate division dismisses a pleading but doesn't say it's with prejudice, does that lower court have the authority to amend the pleading? To find out, you have to read Favorite Limited versus Chico, but it's 26 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases, and I try to do it in 5 minutes or less. This is the episode on the case of Favorite Limited versus Chico. The citation for this case is 2024 New York Slip Opinion 01496, published by the Court of Appeals on March 19th of 2024. The issue in this case is whether a court is allowed, if it has the discretion, to allow an amendment of a complaint after the appellate division has ordered that complaint dismissed, but was silent as to whether it was with prejudice or without prejudice. To understand and appreciate the context of this case, the background that's helpful to know is that under CPLR, Civil Practice Law and Rules 3025, that statute governs when a party is allowed to amend their complaint. And basically, within 20 days after filing a pleading, a party can amend their pleading without any permission from anybody. But after 20 days, a party needs permission of the court, needs leave of the court to amend a complaint, to amend a pleading. But it states that leave shall be freely given upon such terms as may be just. And the cases have basically said that the court should consider whether there's surprise or unfair prejudice. But in the absence of surprise or unfair prejudice, the court really should be allowing parties to amend their complaints, their pleadings. The other thing you have to know that's helpful is that the general rule is that when an appellate court speaks, when a case goes to an appellate court, a higher court, and they give a ruling, the lower court must comply with that ruling. The general rule is that when an appellate court remits a case to the trial court, means sends it back, further proceedings in the trial court must be consistent with the appellate court's remittitor. So you have to comply with that. Okay. What are the facts in this case? The facts are that there's a 5-story apartment building, a 5-story residential building in New York City, in Manhattan. And in 2006, investors create a corporation called Upper East Side Suites, UESS, okay, which is a Delaware corporation. And they make this corporation for the purpose of buying that 5-story building and converting it into short-term rentals like Airbnb. The company had 2 managers that were in the documents that were filed with Delaware, brother and sister Carla and Benedetto Chico, who were both Italian nationals. The company got the building, but the business failed because New York City passed a rule that basically didn't allow Airbnb anymore. So they had to sell the building in a distress sale. The Chicos then used the money as a down payment for another building, but it ended up forfeiting that down payment when the sale failed to close, leaving no money returnable to the investors. So the investors are mad at the Chicos because the business failed. They took the money that they claimed was not authorized to use, and they bought another building, which failed, and so they got no money back. They claim the Chicos lied about the operation, and purchase of the second building was never authorized. So they removed the Chicos as managers of the corporation, of the Upper East Side Suites. And they then sued them for breach of operating agreement, breach of fiduciary duty, and other related claims. This is complaint number 1. Let's call this complaint number 1. What they didn't know is that when the Chicos were removed as managers, they resigned as agents from the Delaware Corporation. So the Delaware Secretary of State canceled their corporation documents, their certificate of formation. So at that point, the original complaint was dismissed when they lost counsel and failed to appear. So the plaintiffs they asked for and they were permitted to file an amended complaint. We'll call this complaint 2. They filed the amended complaint. The Chicos then moved to dismiss, saying that the suit could not be brought on behalf of the canceled Delaware Corporation. So one of the investors got a certificate of revival and asked for permission to file another amended complaint, which they did. They got permission. So then we'll call that complaint number 3. At that point, the Chicos moved to dismiss. At that point, the Chicos filed counterclaims and appealed, saying that this was bad. This was not properly recertified by the Delaware Department of State, Secretary of State. It goes to the appellate division, and the appellate division grants the motion to dismiss by the Chicos, and they issue a decision saying that there was no evidence the company had authorized the investors to act in this way. It was not valid. And specifically, the order says, order entered October 30th, 2018, which denied defendant Benedetto Chicos and Carlo Chico's motion to dismiss the amended complaint and granted in part plaintiff's cross motion for leave to file a second amended complaint. Unanimously reversed in the law without cost, the motions are granted and the cross motion denied. The clerk is directed to enter judgment accordingly. So that's the decision from the appellate division. They send it back to the Supreme Court, where the plaintiffs then tell the court, we'll fix it. Okay? You're saying that we didn't have authorization. You're saying we don't have the documents in order from Delaware. We can fix that. And they seek leave to file another amended complaint, the third amended complaint. They do. The Chicos oppose it. The court allows it. And based upon judicial economy, the appellate division reverses and says, there was nothing left to amend. Because we had sent it down to you, telling you we're dismissing it, you can't amend a dismissed pleading. That's what the appellate division says. It goes to the Court of Appeals, and the Court of Appeals considers this, and this is a big fight in the Court of Appeals. There's a majority in dissent. The majority here by Judge Wilson says, did the court have discretion to allow the amendment? Yes. Why? Because our general rule is that there's discretion, and we have a liberal pleading standard. We want the court to freely grant applications to amend, unless they're surprise or prejudice. Here, the amended complaints were always the same. They basically no new claims are being proposed. It's just fixing defects. And also, according to Judge Wilson and the majority, they say here, the action remained pending because of the counterclaims that were filed by the Chicos. So the Supreme Court still had control over the parties. Secondly, would it have violated, this is a bigger question here, did the amendment violate the appellate division's order, which said dismiss? And the answer is no. And why? He said, and the majority said, under CPLR 5013, a dismissal of a complaint before the close of evidence is without prejudice unless it says it's with prejudice. And here it was silent as to whether it was with prejudice or not, and therefore it was without prejudice. And as a result, the court still had authority to allow an amended complaint. And they say this happens all the time. Parties move to dismiss and amend. If they move to dismiss and amend, that means you're allowed to amend in the circumstance of a dismissal. There is a strongly worded dissent by Judges Rivera, Garcia, and Troutman. They oppose all those different allegations, all the different scenarios. They say the silence does not allow amendment. They say it does not happen all the time, and they say the counterclaims were dismissed too. So there's nothing to amend. But again, the majority here says you are allowed to amend a complaint if it's sent down from the appellate division to dismiss if it doesn't say it's with prejudice. And that's the case of Favorite Limited versus Chico. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.